Welcome back. How lawyers can be effective advocates was the subject of discussion at a training for lawyers and law students organized by the Conference of Western Attorneys General CWAG United States. CWAG, through its alliance partnership, is a cooperative program aimed at strengthening the legal systems of the U.S., Mexico, and many other countries. The three-day training was organized in collaboration with the Nigerian Institute of Advanced Legal Studies and the law firm of Punuka Attorneys and Solicitors. The theme was oral advocacy in Nigeria.
A former director of public prosecution, DPP Lagos, Mr. Fola Othowori, says that cross-examination is the most effective tool to challenge the opposing party's case. He spoke on the topic cross-examination, basic principles and techniques in criminal and civil trial. For him, a counsel's duty is to use his opportunity for cross-examination to change the court's perception of the case of the opposing side.
In a criminal case, a party would consider its cross-examination successful if such witnesses at least accept that particular aspects of the case put to them are probable. You've described a wound, doctor, to the back of the deceased's head, right? You said that in your opinion, that wound was caused by a blow to the back of the head with such and such object was. But it's also possible, doctor, that such a wound could also come from a fall. Yes, in some cases, thank you. That's all. Don't go ahead. Tell us what type of... Stop. So you've introduced that, but it has to tie to you can't just bring it out of the blues. You have to have some element of your case that supports that opinion. So, in civil cases, the goal of cross-examining counsel is to put to each of his opponent's witnesses in turn so much of his own case as concerns that particular witness, on which he had any part, and to get the witness to accept them as true or at least probable or plausible. So you want to change the court's perception of the other side's case through your cross-examination?
A Deputy Chief Criminal Division Rhode Island Attorney General's Office, Scott Erickson, who spoke on fundamentals of oral advocacy, urged prosecutors to make effective use of plea bargaining.
I can tell you that certainly in the U.S., it happens the majority of time. I would guess that in my jurisdiction, like I said, we've got about 1 million people. We probably average about 6,000 or 6,500 felony charges a year that our office prosecutes. We have maybe 40 or 50 prosecutors that are going to handle all those cases. Of those cases, we probably try about maybe 200. So if you do the math, you're talking 5,800, 6,000 cases that are somehow disposed of every single year by some type of plea negotiation. The system couldn't handle it, at least from where I work, if every case went to trial. It just couldn't handle it.
Another of his colleagues talked about some other differences between the two jurisdictions.
From the civil law point of view, what seems to be the most different is that direct examination, direct evidence is presented in writing rather than by examination, oral examination. From a criminal side, I would really defer to my colleague Scott Erickson, who talked about it. For example, today Scott talked about that cases are in the United States are generally decisions made as to whether or not they can go forward by use of a grand jury, which I understand is not the case in Nigeria. Oh, and I'm sorry, pretty clearly I think a very key and salient difference would be that in Nigeria, as I understand it, the trials are not by juries, which, as Scott mentioned today, is a pretty key element of United States practice.
And just before we go, let's do a recap of some of the top trending stories from the courts.
We begin with the report that the Code of Conduct Tribunal sitting in Abuja, the Federal Capital Territory, on Wednesday, the 14th of June, dismissed the case of false assets declaration against Nigeria's Senate President Dr. Bukola Saraki. The tribunal chairman, in his lead ruling, exonerated the Senate President of all the charges, and ruled that the prosecution failed to prove a prima facie case against him. He described as absurd the fact that neither the Senate President's statement nor the report of investigation said to have been carried out against him was produced before the tribunal. The tribunal chairman also held that the evidence adduced by the prosecution, led by Mr. Rotimi Jacobs, was so unreliable that no reasonable tribunal could convict anyone based on it. Staying in Abuja, the appeal court has nullified the October 2016 judgment of the Code of Conduct Tribunal, which found a former Minister of Niger Delta Affairs, Gosde Orubebe, guilty of false assets declaration. The CCT, led by its chairman, Danladi Umar, had ruled that the prosecution had proven its case against Mr. Orubebe and confiscated the asset, a landed property located at number 2057 Asokoro, Abuja. The tribunal, however, found Mr. Orubebe liable on the grounds that the documents indicating that the property was sold were not legally sufficient to prove a transfer of ownership. In a ruling on Wednesday at the appeal court, a three-member panel of judges led by Justice Abdu Aboki said the documents presented at the lower court was sufficient to indicate transfer of ownership. The court also ruled that Mr. Orubebe was not expected by law to declare an asset he'd already sold. In the case against the former National Security Advisor, Colonel Sambo Dasuki, for possession of firearms and money laundering, the Federal High Court has granted leave to the federal government to shield its witnesses. Justice Ahmed Mohammed in his ruling said the witnesses will, however, not be shielded to the lawyers in the case and the defendant. In giving the ruling, Justice Mohammed said the application before his court is different from the application which was dismissed when the case was before Justice Adeni Ademola on April 8, 2016. According to him, in that suit, the prosecution did not ask for the witnesses to be shielded, and in the current case, the defense did not show how shielding the witnesses will be injurious to the defendant. In Kaduna, a federal high court has adjourned the case between the leader of the Shiite movement, Ibrahim El-Zakzaki, and the federal government till June 30th, 2017. Senior Advocate of Nigeria, Mr. Femi Falana, filed the suit which has the Chief of Army Staff, Lieutenant General Tukur Buratai, and two others as defendants. In the suit, the Shiites are demanding 2 billion naira as compensation for the invasion and destruction of El-Zakzaki's house, the killing of his 3 sons and other members of the Islamic movement by the Nigerian army, which they say amounts to the violation of his fundamental human rights. But at the resumed sitting on the matter on Thursday, hearing on the suit could not go on. This is because lawyers to the first, second, third, and fourth defendants in the suit had filed an objection describing the suit as an abuse of court processes since the applicants had earlier filed a similar suit at court of same jurisdiction in Abuja. The applicants, however, filed a counter-affidavit insisting that both suits are different and should be treated differently on their own merit. The lawyers for the defendants then sought an adjournment to enable them to study the issues raised before the next sitting. In his ruling, Justice Shaibu informed both parties that all the objections will be heard on the next adjourned date, 30th of June 2017. And we round off with a report that the Economic and Financial Crimes Commission has brought a charge of unlawful enrichment against Justice Hailazira Ajiya Nganjiwa of the Federal High Court, Bayelsa Division. The EFCC filed the 15-count charge before Justice Adedayo Akintoye of the Lagos High Court in Igboshere. But Justice Nganjiwa, who filed a preliminary objection challenging the court's jurisdiction to hear the charge, was not available for arraignment. His lawyer, Robert Clark, says the judge failed to catch a flight from Yenagoa, the Bayelsa state capital. The lawyer also made a preliminary objection that the court did not have the jurisdiction to hear and determine the case. The EFCC prosecutor, Mr. Rotimi Oyedepo, however, challenged the defendant's non-appearance and urged the court to dismiss the preliminary objection. Justice Adedayo Akintoye has adjourned the case until June the 23rd for ruling on the preliminary objection.
That's the program for today. Please share your views with us on any of the issues we've discussed on the program. If you missed any part of it, you can find it on past episodes on our YouTube channel. I'm Shola Shayeli. Thank you for watching.